The United Kingdom's departure from the European Union initiated a profound legal and constitutional restructuring. This analysis explores the legislative mechanisms, judicial shifts, and policy implications that have redefined the UK's legal framework, offering insights for legal professionals, policymakers, and the general public alike. The European Union Withdrawal Act 2018 served as the foundational legislation for Brexit. Its primary objective was to ensure legal continuity and stability during the transition. This act formally repealed the European Communities Act 1972, thereby ending the automatic supremacy of EU law within the UK legal system. Crucially, the 2018 Act introduced the concept of retained EU law. This mechanism converted existing EU law into domestic UK law at the point of withdrawal, preventing a legal vacuum. This strategic move allowed for an orderly exit while providing a basis for future legislative amendments. Post-Brexit, the UK legal system categorizes former EU law into distinct types. Direct EU legislation, such as regulations and decisions, now functions as assimilated law within the UK. Similarly, EU-derived domestic legislation, which includes UK acts and statutory instruments implementing EU directives, also falls under this assimilated status. A significant change concerns directly effective rights, which previously empowered individuals in UK courts. While some were initially retained, the Retained EU Law, Revocation and Reform Act 2023 has largely repealed their direct effect, shifting the legal landscape for individual claims. The interpretation of retained EU law has undergone a fundamental transformation. Prior to 2024, UK courts were generally bound by pre-Brexit rulings of the Court of Justice of the European Union, CJEU. However, the Retained EU Law, Revocation and Reform Act 2023 significantly altered this. UK courts are now empowered to depart from CJEU precedent, applying domestic interpretative principles. This shift, exemplified by cases like Lipton v. BA City Flyer Ltd. 2024, underscores the reassertion of judicial autonomy. The CJEU's judgments are now considered persuasive but no longer binding, marking a clear divergence in legal authority. Parliament and government ministers have gained substantial powers to modify, replace, or revoke retained EU law. This legislative flexibility allows the UK to tailor its legal framework to national priorities. Over 1,000 statutory instruments have been enacted to amend or repeal aspects of retained EU law. The sunsetting of nearly 600 pieces of EU law by the end of 2023 demonstrates the active process of legislative reform. This ongoing rewrite reflects a deliberate policy choice to diverge from the EU acquis where deemed appropriate, impacting sectors from agriculture to environmental regulations. A central tenet of Brexit was the reassertion of parliamentary sovereignty. The Withdrawal Act and subsequent legislation have restored Parliament's ultimate authority to make and unmake laws without external constraint. This constitutional principle is now fully operational, allowing for independent legislative action. However, this sovereignty operates within the context of international agreements, such as the Trade and Cooperation Agreement and the Windsor Framework. These treaties, particularly concerning Northern Ireland, introduce specific obligations and continued alignment in certain areas, illustrating the complex interplay between national sovereignty and international commitments. The UK now operates as a third country in relation to the EU, necessitating a new framework for engagement. While divergence from EU law is possible, it carries potential implications for trade and political relations. The Windsor Framework, for instance, maintains a role for some EU law and the CJEU in Northern Ireland, reflecting its unique status. Cooperation continues in various sectors, such as scientific research through Horizon Europe, indicating a pragmatic approach to post-Brexit relations. Understanding this evolving legal and political dynamic is crucial for navigating future interactions and policy decisions between the UK and the EU. To delve deeper into these critical legal and political developments, explore the primary legislation, judicial decisions, and policy briefings mentioned. Engage with legal scholars and political analysts to understand the ongoing implications for the UK's constitutional order and its international standing.